Thanks everybody for coming. As Sean mentioned, my name is Gabe Rottman. I am the director of a new project on technology and press freedom at the Reporters Committee for Freedom of the Press. We're a nonprofit that provides free legal services to journalists around the country. And my project looks at issues like the Computer Fraud and Abuse Act that potentially intersect with free expression, free press, and technology. So great to be here and excited for the discussion. The impetus behind this panel was the April unsealing of an indictment against Julian Assange, the co-founder of WikiLeaks. The initial indictment was one count of conspiracy to violate the Computer Fraud and Abuse Act, which I'll mention in a few minutes, is a law dating back to the mid-1980s. It's the general federal computer crime law, and it was meant to target hacking, the use of technical measures to circumvent technical access restrictions in a computer, but it's been extended since then. And the Assange indictment, the conspiracy charge, was an interesting one. I'll talk about it also in a bit more detail in a second. But it brought the Computer Fraud and Abuse Act once again to the public eye, and it raised a lot of issues that are not unique to the Assange case, and we thought it would make sense to talk about them here, as well as the various policy issues at play and legislative issues at play. So with that, I'll just turn it over to our panelists to introduce themselves, their organization, and maybe say a bit about what they do around the Computer Fraud Abuse Act. And
then should I do my whole spiel now? Or
yeah, why don't you do that?
Okay.
Yeah.
So I'm David Segal. I am. Oh, thank you, Sean. I'm David Segal. I am co-founder and executive director of Demand Progress, and we work on a variety of issues related to computer policy, things like net neutrality, opposition to censorship, but have a particularly tragic relationship to the Cfaa, and that my co-founder was Aaron Swartz, who, as many of you may remember, killed himself in 2013. While under an indictment for innumerable violations of the Cfaa, which I'll speak to in a bit. Cfaa is an incredibly vague and harsh statute, leaving determinations about potential violations to the discretion of prosecutors and judges who frequently have very limited understanding of the operations of computers and computer networks and so on. So there are myriad ways to be construed to have violated it, which is part of why its use to attack journalistic acts is so concerning. Many normal uses of computers fall into the ambit of what has been prosecuted or held to be illegal under the Cfaa. And so what does the statute do? Part of the statute's devoted to attempts to secure state secrets. Part of it's essentially the anti-denial of service attack law, though even this is problematic, which I'll get to in a bit. But I think the statute's extraordinary breadth and problematic nature is made most evident in that it makes it illegal to intentionally access a computer without authorization or while exceeding authorization if one thereby obtains information from any protected computer or causes damage or loss. So damage and loss have been very broadly construed. The law doesn't define without authorization. Its definition of exceeds authorized access is disputed, defined as access to a computer with authorization and to use such access to obtain or alter information in the computer that the accessor is not entitled so to obtain or alter. And a protected computer at this point is, as far as I can tell, essentially any networked computer. Definition is one which is used in or affecting interstate or foreign commerce or communication. So anything that's online. The government has at times argued that violating a terms of service agreement for computer network or site is a CFAA violation, or even that violation of a corporate policy means that you've exceeded authorized access. So charges have been brought for things like violating MySpace's terms of service by creating an account under a fake name. Somebody was convicted in the Seventh Circuit for deleting information from a company-provided laptop shortly after quitting a job and before returning the laptop, because quitting implied revocation of authorization to use the laptop that he still possessed. In the Ninth Circuit, you violated CFAA if you log into a computer with credentials voluntarily given to you by a coworker, if it's against the company's policy to share passwords. And in the Power Ventures case in the Ninth, it was decided that receipt of a cease and desist order was tantamount to revocation of authorization to access a network, and continued attempts to access it, for instance, by crawling or scraping a public-facing site whose terms of service say that such actions aren't permitted, is a CFAA violation. My co-founder, Aaron, as I mentioned, was subject to perhaps the most infamous CFAA prosecution to date, and in his case, the charges entailed initially 3 CFAA counts, and under a superseding indictment, eventually 11 such counts for allegedly downloading too many academic articles hosted by the JSTOR cataloging service, to which he had legitimate access, from MIT's infamously open campus network. And the bulk of these charges related to ostensible unauthorized access to MIT and/or JSTOR networks. JSTOR, the entity that conceptually probably had the strongest claim to potentially having been harmed, didn't want to press charges after it secured an agreement that the materials would be returned and not released. MIT cooperated with the authorities while asserting its ostensible neutrality in the matter, and after Aaron's death, MIT constituted a review panel to develop a deeper understanding of the institution's involvement in the case and the implications thereof. And the panel found that it was only after the initial indictment, which alleged various violations related to MIT's policies, the prosecutors even asked MIT for its current network terms of service. And the panel found that it was at best ambiguous when they tried to determine if Aaron had engaged in unauthorized access to their own network. And here's a quote from their determinations. As far as the review panel could determine, MIT was never asked by either the prosecution or the defense whether Aaron Swartz's access to the MIT network was authorized or unauthorized, nor did MIT ask this of itself. Given that, 1, MIT was the alleged victim of counts 9 and 12, 2, the MIT access policy, its rules of use, and its own interpretation of those rules were at the heart of the government's CFAA allegations in counts in both indictments, and 3, this policy and these rules were written, interpreted, and applied by MIT for MIT's own mission and goals, not those of the government. The review panel wonders why. And Aaron hanged himself 2 years after his initial arrest, a few months before his trial was to begin. And just onto that denial of service provision, when we think of a denial of service attack or a DDoS, a distributed denial of service attack, we think of a bad actor or bad actors pinging a machine with so many frivolous requests that it basically can't engage with legitimate requests any longer. And these attacks are charged under a provision of the CFAA that says that one cannot knowingly cause the transmission of a program, information, code, or command, and as a result of such conduct, intentionally cause damage without authorization to a protected computer, so to any computer. This language, or the notion that we ought be constraining this behavior seems completely reasonable, but there's an extraordinary case in the Sixth Circuit wherein a plaintiff suing under the CFAA's private right of action was found to have stated a claim against the laborers union for a CFAA violation for effectively having engaged in a DDoS attack because LIUNA had encouraged members and activists to email and call a campaign target, in this case called Pulte Homes, which is a home contractor, which LIUNA had thought was engaging in illegal union busting, because the emails and calls that were sent were tantamount to a transmission that weakened a computer system or diminished the plaintiff's ability to use data or a system, because they made it harder for the company to conduct normal business during the period during which they were the campaign's target. Court's opinion is insane. It's the calls clogged access to Pulte's voicemail system, prevented its customers from reaching its sales office and representatives, and even forced one Pulte employee to turn off her cell phone. The emails wreaked more havoc. They overloaded Pulte's system, which artificially limits the number of emails in an inbox, and this in turn stalled normal business operations. These Pulte's employees could not access business-related emails. And that's a CFAA violation, prosecutable, both criminally and civilly. This is of particular concern to an organization like mine, which regularly mobilizes thousands, in some cases millions of people to engage around concerns like net neutrality, SOPA, PIPA, and in those moments we had phones in this building literally ringing off the hook to the point where business probably was substantially disrupted because we were trying to get a legitimate political point across, and eventually led to substantial change in the course of the passage or non-passage of those legislative vehicles. There's been some movement in D.C. in light of heightened attention to the CFAA, especially after Aaron's case, and so recent happenings include that every year or two there's an effort to expand the CFAA along some dimension or another in harshened penalties, and this is unfortunate. We haven't dealt with it in the last couple of years, but the fact of the attention to Aaron's case and concerns about CFAA more broadly have enabled us to block these efforts in substantial part with the help of Senator Wyden and a few allies in the House and Senate. In 2014, and then made public in 2016, the Obama administration offered guidance around CFA prosecutions that was almost certainly substantially rebuked the prosecutors in Aaron's case, among other things seeking to ensure that prosecutions entailed a serious federal interest and doing a bit of work to tighten up an understanding of what exceeding authorized access means, but we don't actually know, as far as I know, whether this memo still operates. And then there's Aaron's Law, named after Aaron, which has been introduced a couple of times, though not yet during this Congress, which gets rid of the exceeding authorized access claims altogether and relies on access without authorization while defining that as an effort to obtain information on a protected computer that an accessor lacks authorization to obtain by knowingly circumventing one or more technological or physical measures that are designed to exclude or prevent unauthorized individuals from obtaining that information. So essentially saying that a TOS violation, a violation of corporate policy, is no longer a CFAA violation, but you need to actually engage in some sort of technical attack to circumvent a technical barrier in order to be charged. And I'll leave it there for now. Happy to answer questions and want to give these guys a chance to talk.
It's a good seg into, Esha, you're challenging one of the worst provisions in the CFAA, so eager to hear about that.
Hi, everyone. Hi, my name is Esha Bhandari, and I'm a staff attorney in the Speech, Privacy, and Technology Project of the American Civil Liberties Union. And David's description of the problems with the CFAA is a good segue into what I'm going to talk about, which is primarily a challenge to the CFAA's exceeding authorized access provision. And this challenge is brought on behalf of computer scientists and a media organization who want to conduct online anti-discrimination testing. It's essentially the equivalent of offline audit testing in the housing or employment context, but they're stymied by the CFAA. So to give the big picture background behind this case, at the ACLU, in the last several years, we had become interested in thinking about the ways in which existing civil rights laws might be being circumvented online. So for example, protections in the Fair Housing Act, Title VII, which prohibit discrimination in providing housing opportunities or employment opportunities, those protections, which do apply online, nonetheless, there are new forms of discrimination emerging online that we were concerned weren't being uncovered, weren't being enforced against. So, for example, offline, while it may be very rare these days to see job ads that say men wanted or women wanted, the passage of the civil rights laws essentially eliminated those types of job ads. Online, the same thing can be accomplished through ad targeting. I think probably most people are familiar in this room with that concept, but just briefly, a lot of social media platforms, a lot of widely used employment platforms will allow advertisers, employers, and others to pick the audience that sees their ads. And, because of the way that the online ecosystem has developed, many of those platforms were and continue to allow people to show ads based on gender, based on race, based on age, things that are prohibited by the civil rights laws. And that's intentional ad targeting. But then, of course, we've got the separate problem of algorithmic ad targeting, where you may have, let's say, an employer wants to show their ad to people more likely to click on it. And they don't pick the audience, but the platform does it for them. And of course, platforms compete on this, right? They tell advertisers, we will most efficiently show your ad to people who are likely to click on it, likely to be interested in your opportunity, and we'll use an algorithm to do it. And so, I think unfortunately what we now know is the bias that can result from the use of algorithms, either because of the data that they're trained on, the data that they're using, or other issues that arise can result in biased outputs. And so again, academic studies have slowly started to come out recently looking at this phenomena and saying, in this particular context, for example, if I were to go to a job board, let's say, one of the major job boards, and if I were to search for engineering jobs, would I be shown different opportunities based on my race or based on my gender? Or on the flip side, if I'm an employer looking for someone to fill a position, and I create an account on one of these job boards, and I search for engineers that I could hire, what will the rank order of candidates be? And just because of, the way things work, we know if you're on page 100 of the list, you're probably less likely to be seen by an employer than if you're on page 1 of the list. And so rank ordering matters. And if the algorithms that rank candidates are biased in a way that would raise concerns about civil rights, this is something the public needs to know about. So inspired by this problem and thinking more about how we could deal with the problem of algorithmic discrimination and civil rights enforcement, we came across this separate issue, which is that many of the computer scientists, academics, journalists, and researchers who wanted to test for this were running up against the problem of the CFAA. And David has already explained well what the problem is, which is if you violate terms of service, you can be deemed to be exceeding authorized access. And it is quite common for website terms of service to contain prohibitions like no scraping of the website, even if it's a public-facing website, no creating false accounts or providing any false information. Some of them we've even seen say things like you cannot use this for research purposes. You can only use it for, searching for a house or searching for a job. A lot of them prohibit sharing any information you find on there, which again seems like an outrageous term of service because anyone who has ever copy-pasted a job ad to, email themselves or email a friend, you could be committing a CFAA violation if that website puts up a term of service saying no manual recording, no copying, no sharing of anything on the site. So the overbreadth of the CFAA was really artificially depressing the amount of research that was going into this problem of algorithmic discrimination. And so we challenged the CFAA, we challenged the criminal prohibition and the exceeds authorized access part of the CFAA on behalf of computer scientists who do this type of research and who want to do it free from the threat of criminal prosecution. And we are in the district court in the District of DC. We are now at the stage of the case where we have completed summary judgment filing. We had a whole process of discovery, but I'll just mention a few noteworthy things about what has happened in the process of the case so far. One, at an initial stage of the case, the judge ruled that not all terms of service violations are, in fact, CFAA exceeds authorized access violations. In fact, specifically, he said prohibitions on scraping or recording information that's otherwise shown to you is not a CFAA violation. And he said because it's not an access violation. If you have been given information, if you have been given data, what you then do with that isn't an access violation, right? So the social media companies, the platforms may be unhappy if you then turn around and say, look at what was on their platform on X day. But they made the decision that, they were either going to give you that information or they were going to make it publicly available. And so that was a distinction in the interpretation of the CFAA. And so the judge dismissed the plaintiff's claims based on scraping, but again, in a helpful way because journalists, data journalists, academic researchers use scraping quite often. And so I think that was a very helpful opinion to give some comfort to people engaged in that work, regarding whether the CFAA could cover that. And hopefully that is persuasive to other courts considering the issue. So the claim that we went forward on specifically was the providing false information or creating fake accounts claim. And our clients, the plaintiffs in the case, are arguing that they have a First Amendment right to provide this false information to websites in the course of their testing for discrimination. And, we've filed our briefs and we've made our argument. And, I think the critical thing to note is even though, the government has made arguments about why it needs the CFAA to protect against the proliferation of bots on the internet, misinformation, fake news, all of that, at the end of the day, the question is whether the First Amendment would protect someone engaging in this type of research, providing false information in this way. So I think, in fact, the problem that's troubling with the government's position is it's just too broad, right? We all know the internet is full of fake accounts. Some of them may lead to harm, but certainly if the position is that, the whole universe of activity that people engage in on the internet could potentially fall under the ambit of the CFAA, that's going to have a very chilling effect on everybody, right? I mean, think about anonymous accounts or pseudonymous satire parody accounts on social media. One, they're not using real names. Two, even people who use their real names on their account, in the back and forth of political discussion, what have you, people don't always provide truthful information, right? There's exaggeration that is rampant. There might even be false information put out there that people intend or don't intend. But the idea that the CFAA could criminalize all of that false information when terms of service prohibit it without considering whether that is protected under the First Amendment, I think that goes too far. And so, I think the posture of our case, hopefully we can persuade the courts that, this aspect of the CFAA criminalizing this particular research behavior is unconstitutional. That, of course, still leaves the problem of people who are not researchers who might still be subject to the CFAA, right? There's a whole swath of other activities that are covered under the exceeds authorized access prong, which, I think put people at the mercy of federal prosecutors.
Great. Thanks, Esha. Ramya, do you want to talk about Knight?
Sure.
Great.
Hi, everyone. My name is Ramya Krishnan. I'm a staff attorney at the Knight First Amendment Institute at Columbia University. We're a relatively new organization. We were founded a couple of years ago with the mandate of protecting and defending the freedoms of speech and the press in the digital age, which is why we're very much interested in the CFAA, and some of the work that we've done very much ties in with the ACLU's work on this. So we've been primarily interested in the ways in which the Computer Fraud and Abuse Act impede digital journalism and research on the social media platforms. Last August, we wrote to Facebook, basically asking them to amend their terms of service to create a safe harbor for certain kinds of digital journalism and research on their platform. Journalism and research that would appropriately protect the privacy of their users and also the integrity of their platform. And the reason we wrote to them was Facebook's platform, along with the platforms of other major social media companies, have a really enormous influence on public discourse right now, public discourse and democracy. And they're shaping public discourse in ways the public is only really beginning to understand. So journalists and researchers play a pretty crucial role in illuminating that influence, but the terms of service of these companies, together with the CFAA, are severely limiting the ability of these journalists and researchers to study these companies because they fear not only account suspensions and shutdowns and potentially breach of contract liability, but also civil and criminal liability under the CFAA, because the CFAA allows not only the DOJ to come after someone who has violated a website terms of service, but also private companies, because it establishes a private right of action. And so potentially the social media companies could go after journalists and researchers simply for violating their terms of service. So maybe if I give an example of the kind of journalism and research that is currently being impeded. We were approached a couple of years ago now, I guess, by a journalist who had identified a way of basically mapping the popularity of related pages using user engagement in order to identify previously unknown sources of misinformation. And it was possible, I guess, for him to try and do that manually, but that was obviously not feasible because he was trying to analyze the problem of misinformation at scale, and to do something like that, he would need digital tools. He would need the ability to scrape public information on Facebook, and he would also need the ability to create fake accounts or temporary research accounts. Both of those things, things which are considered to be the sort of basic tools of people who work in this space, are prohibited by Facebook's terms of service. And so he was actually told by in-house counsel at his news organization that because of the risk of CFAA liability, he would not be allowed to pursue that project. Since speaking with him, we've spoken with dozens of other journalists and researchers who study the social media companies, and they've all expressed this sort of concern, the concern with the prospect of both civil and criminal liability under the CFAA, and have described the ways in which the CFAA have chilled their work, either by causing them to modify their work in ways that would make their work less valuable, or by simply causing them to abandon their projects altogether. So we wrote to Facebook asking them to amend their terms of service to create a safe harbor that would essentially create the breathing space that these journalists and researchers need in order to do their work without the fear of legal sanction. And the safe harbor basically said a journalist or researcher does not violate Facebook's terms of service by engaging in automated collection of public information or by creating or using temporary research accounts as part of a news gathering or research project if they satisfied certain conditions. And those conditions were basically as follows. The purpose of the project had to be to inform the general public about a matter of public concern. The individual had to take reasonable measures to protect the privacy of Facebook's users, and we basically set out a number of conditions that we thought would prevent any researcher from abusing the safe harbor in the manner of, say, like a Cambridge Analytica. If a journalist or researcher created a temporary research account, they had to ensure that they didn't, mislead any human Facebook users as opposed to, say, Facebook's algorithms. And they had to abstain from sort of conduct that would impair or significantly interfere with the integrity of Facebook's platform. And since sending that letter to Facebook, we have been in negotiations with the company. Their sort of main concern has been user privacy, and we have basically been in negotiations with them about whether there is any kind of safe harbor that they would be comfortable implementing in their terms of service, or whether they would be comfortable issuing a public statement that would offer journalists and researchers at least some soft assurance that they would not go after them using the tools of the CFAA or their terms of service. So that's a bit about our project.
Great. It's actually the way that you framed it tees up sort of, it shows exactly what the fundamental issue is with the CFAA. I mean, the Computer Fraud and Abuse Act, the history of it, it's pretty clear that it meant to deal with what is colloquially known as hacking. But the way that it has evolved over time, it covers activity that, when done without automation, would not be a criminal or a civil offense. But as soon as you automate it, it becomes a potential CFAA violation. And that problem is wrapped up in the history of the law, which is sort of slightly comical and an interesting exercise in fiction influencing public policy, but it also shows how the law has sort of changed and the fact that Congress did not include a workable definition, didn't include a definition of hacking or accessing a protected computer without authorization. The lack of that clarity has now led to the situation where, particularly in discrimination cases, an act that would be legal if not automated becomes illegal if automated. There's a great example of sort of the proto data journalism that you're seeing take place online today. One of the first data journalism initiatives was a series of articles in the Atlanta Journal-Constitution in 1988 called "The Color of Money," and what the author of those articles, Bill Dedman, did was he collected en masse data from both government entities and financial institutions on mortgage lending in predominantly African American and predominantly white neighborhoods in Atlanta, and he was able to show by collecting that data and sort of crunching it but not doing it online that there was a severe disparity in terms of the credit terms that were being offered to African American families versus not. And that's exactly the type of activity that, and using test accounts is exactly the kind of activity that is covered or potentially covered by the CFAA because of this lack of a definition of without authorization. So the automated collection of publicly available information online, as well as using test accounts online in the non-digital context would be not only perfectly acceptable, but standard operating procedure in housing discrimination investigations. And then once you transfer it online, it becomes potentially criminal or at least subject to a civil complaint. Please.
I want to add an example to what Gabe said, which is I think, in the recent discussions around criminal justice reform, it has become more common, I think, for state and local governments to put a lot of data about their criminal justice system online. So, records of arrests, convictions, allowing the public, journalists, and researchers to sort of do an analysis about, racial justice concerns, how the criminal justice system is actually operating. And this is public data, right? The public, it's both collected by a public entity, it's made available to the public, and yet to do any meaningful research, you often have to use these automated tools on the websites. Otherwise it's massive amounts of data that is of no use, really, or can't be used most effectively. And I think there are people who are feeling the chill of the CFAA in doing the kind of robust research around that data. So that's another example where this is an unintended consequence.
Absolutely, and people are doing it all the time. News organizations across the country, many of them will employ dedicated data journalists, who scrape, who automatically collect publicly available information online, just on the regular. And so this issue is becoming ever more salient for news organizations across the country. So I would like to address the Assange indictment, and I can just set that up by quickly describing what it is, and then maybe we could talk about our various takes on it. But so, as I say, in April, Julian Assange, in April, a criminal indictment under the CFAA was unveiled against Julian Assange, the co-founder of WikiLeaks. The theory of the indictment is important. The way in which it's structured is important in terms of its implications, broader implications for the Computer Fraud and Abuse Act. It is a conspiracy claim, and legally, a conspiracy claim needs to include an underlying criminal agreement that's sort of the meeting of the minds that creates criminal liability. But then under the law that's used in the indictment, they also, the Justice Department has to allege and prove an overt act by one of the conspirators. So something that one of the conspirators did in furtherance of this meeting of the minds agreement. What's key is that in the indictment is all based on the interactions between Chelsea Manning and Julian Assange in 2010, when the initial leaks from Manning were going to Assange. So it's not based on any more recent activity. The way that the indictment is alleged is it uses a rarely used provision of the CFAA that covers accessing a computer basically to take classified information. And it's similar in structure to the Federal Espionage Act, which is the 1917 law that was passed to cover espionage, actual spying, but has been used in recent years against reporters' sources for the unauthorized disclosure of classified information. So the Computer Fraud and Abuse Act has this sort of mini Espionage Act in it, which is what they're using, what the Justice Department is using. But the overt act, as alleged in the indictment, is that allegedly Assange agreed to receive and himself try and basically guess a password. And so for the Reporters Committee, the breadth of the conspiracy charge, basically the fact that the conspiracy, the illegal agreement in the indictment was to exfiltrate and publish classified information was troubling. But there was this overt act of password cracking, which in the CFAA as originally passed in 1986, the actual thing that it meant to address was using automated means to try and circumvent a technical access restriction like a password gate. So it was very complicated. It was a very complicated issue for us, both legally and in terms of what it might mean for press rights going forward. In the intervening months, the Justice Department has released a superseding indictment, which has been roundly condemned by press freedom and First Amendment organizations because it expressly uses the Espionage Act to punish the solicitation, receipt, and publication of classified information. And in fact, actually 3 counts under the superseding indictment aren't even based upon encouraging a source to give you information or the receipt of that information. They're exclusively based upon the act of publishing classified information online. So the superseding indictment has kind of overtaken developments, but the original Assange indictment was interesting, and one of the reasons why it was interesting is that if you took away this password cracking allegation that Assange himself had said, send me the hash value and I'll try and reverse it, it would have been troubling. And for a variety of reasons. I mean, one of the points that we made when it happened was that if I'm a newsroom lawyer and a reporter comes to me and says a source is asking for help cracking a password to a government network, I would say that we would not want to use our own computer systems for that activity. But by the same token, if you take the analogy of I wouldn't enter other property to break into a safe. It's actually a case from involving Congress of all things. But I wouldn't enter into somebody else's property to crack into a safe. But if somebody sent me the safe to my newsroom, I would want to try and crack the password to see what's in there. And so in the CFAA context, there's sort of a similar issue where reporters get encrypted drives, for instance, on a regular basis. This happened in the Panama Papers, and under the CFAA as written, it's not inconceivable that you could have an argument that trying to access one of those things without authorization outside of this context of getting the password to a government network elsewhere, could potentially raise CFAA concerns. So anyways, it's a bit of a ramble, but if anybody else has thoughts, I'd be eager to hear them, particularly on the Assange indictment and sort of what you think it means for First Amendment freedoms going forward.
I mean, one thing I think that strikes me about that's common between the CFAA and the Espionage Act is how broadly they are written. And so one of the common concerns we have at the ACLU about both of them is they both cover activities that we'd all consider, protected under the First Amendment. Journalistic activities I've just been describing under the CFAA, as Gabe has been describing. But they're so broadly written, they sweep in such a wide variety of behavior that most people would consider innocuous, that it raises the risk of selective enforcement. It raises the risk that the government can prosecute only those that it disfavors, the people who embarrass them, the people who publish critical information. So that strikes me about the commonalities between the two.
I'll excuse me. Sorry, I have open in front of me like the New York Times' blog post where it is How to Tell Us a Secret, and it's a post that explicitly solicits tips, including with a list of examples that entail information that were almost certainly illegally shared by sources. For instance, Trump's tax records from that they published in 2016. So explicitly encourages people to give the New York Times information, at least broadly speaking, that might include information they're not supposed to be making known publicly, in a way that maps to part of the indictment, where you can probably speak to more detail than I can, but at the outset, WikiLeaks essentially had a wish list of information, which seems like it inspired, at least in part, Manning's leaks to them. And simultaneously, you have you have a whole set of instructions about mechanisms by which you can transfer information while maintaining your anonymity to the New York Times, which includes, for instance, use of a secure drop, just a mechanism by which you can upload information anonymously. Then you go to the secure drop page, and it outlines how to go about doing this, and it says things like, go to a place with a widely used network. You go to a cafe, go to a library, and it's just not hard to imagine. And if you're going to one of those places, you're almost certainly violating terms of service agreements. If you're doing something like this there, they say, your use of this network must be in concert with the law. You must not engage in anything that could be construed as a copyright violation. In some cases, you'll be asked to insert your name, and inserting a false name could be construed to be a CFA violation. So you can imagine pretty easily a string of activities that whose end is getting information that might be very much in the public interest to a reporter that entails engaging in any number of CFA violations along the way, and where a reporter might, over the course of those interactions, suggest to somebody, go to a cafe, ignore the terms of service. If they ask for your name, put in a false one, et cetera, and create some exposure for themselves in doing so.
Definitely. So I guess the ultimate question, and it looks like we have about 12 minutes. The ultimate question is, what do we do? What's the answer? I can, for having worked on the legislative and administrative side of CFA reform for a while, it's generally been defensive. The CFA has been amended, I think, 8 times since its passage in the mid-'80s. It's never been narrowed; it's always been expanded. So what do we do? Are the courts the right? Should we rely on the courts? Should we rely on public opinion, or should we go back to legislation? What do you all think? And I open it up to the panel.
I mean, I think obviously it would be great if there was congressional action on this in the right direction, which would be a narrowing, I think, of the CFAA. I think you mentioned some earlier legislative reform efforts to make clear that the CFAA does not extend to mere terms of service violations, and that it is only meant to cover actual action that is intended to and that actually circumvents meaningful technical access barriers. And so I think if we trying to push for that kind of reform is definitely a worthwhile thing. In the meantime, it would be great to see the courts adopt narrowing interpretations of the kind that Judge Bates did in Sandvig, or to reach the conclusion that the CFA is simply unconstitutional to the extent it applies to other kinds of innocuous conduct. And I think bona fide digital journalism research definitely falls in that bucket.
I guess one of the hardest questions that comes up if you're talking about actually a fix either in Congress or the courts is, again, the ultimate problem with the CFAA is that the term without authorization is left undefined. And so it has been expanded to apply to activity that doesn't involve an attempt to circumvent a technical access restriction, a code-based access restriction. But one of the options then would be to try and define hacking. I have views, but I'll again open it up. Is that something that, one, is even doable, and two, is it wise? In the sense of, for computer security researchers in particular, there are distinctions between sort of good hacking and bad hacking, and if you start to attempt to articulate those in laws, do you get into trouble?
Well, one response I have to that, Gabe, I agree that it may be hard and there's a lot of debate going on, but when we're talking about a criminal law, I think it is incumbent on the law to be narrowly tailored. And so if there's a choice between, having a clearly defined criminal law where the prohibitions are obvious to everyone that may leave some behavior on the margins outside of its scope, I think that is preferable to taking the big tent approach, which the CFA and its current interpretations do, leaving people both wondering exactly what behavior is criminal, because it's not often clear. And then even when it is clear that there's this overbroad interpretation that applies to you, potentially it covering behavior that you have a constitutional right to engage in, and there's a public interest in, everyone would agree, is not causing harm, whatever the category is. So I think that, there may not be a consensus overall on what hacking is, but I think certainly there could be, an approach that starts to take the narrower view.
Yeah, I think that the knowingly circumventing one or more technological or physical measures that are designed to exclude or prevent unauthorized individuals from obtaining that information language in Aaron's law, as it's been proposed, I think does some of that work. There were some, I don't have immediate recall of them, there's some like esoteric critiques of even that language from members of our community broadly that I'd want to look at again. But Aaron's law did see, bipartisan purchase. We had Lofgren and Sensenbrenner were the co-sponsors in the House, and in the Senate it varied, but it was Senator Wyden, Senator Paul, and some others over time. And I think it's not completely impossible that we could see this appended to, and would unfortunately probably entail some sort of like comprehensive revision that would also entail some number of penalty enhancements or expansion of criminality along other dimensions. But this appended to one of those vehicles, if it seems like it's definitively going to move, seems like a possible way of having it vest. And you need to take the totality of that in the moment to determine whether or not that was on the net good or bad.
So one other thing I neglected to bring up, but I should mention quickly also is, and it goes to maybe not affirmative reform, but also what some of the defensive challenges might be in terms of policy proposals that have been made in the recent past. Actually, our three groups, ACLU, the Knight Institute at Columbia, and Reporters Committee, signed an amicus brief, a friend of the court brief, in the lawsuit by the Democratic National Committee against various actors involved in Russian interference in the election. The amicus brief that we signed was just in support of WikiLeaks, not Assange or any of the other defendants. And it was because one of the arguments that is being made in that lawsuit is that you can have effectively a racketeering conspiracy under RICO, the federal racketeering law. That you can have a racketeering conspiracy where an entity that publishes information that publishes information is being wrapped up in that racketeering conspiracy merely for coordinating with the source of the information, and even when they weren't, when that entity wasn't involved in any of the underlying alleged sort of wrongdoing, right? So that the analogy in the journalism context would be, a reporter who's receiving information and coordinating on when to publish the story, how to phrase the information, and so we filed a friend of the court brief saying that in and of itself can't be the basis for a RICO claim. Under the last administration, there was a proposal to expressly make various provisions of Section 1030, the CFAA, a RICO predicate, which was of great concern. And that could end up starting to cover if you're in a chat room where people are discussing hacking techniques, even in the abstract, you could theoretically come under the ambit of a RICO claim. So that's one, that's one very specific thing that could come down the pike, which would be, greatly troubling. We have about 5 minutes left, but I don't think we're getting kicked out, right, John? Right. Okay, so we'll be around for any questions. What's next? I mean, what do we see coming down the pike? It is true that we haven't seen a high-profile criminal prosecution under the CFAA like you saw with the Aaron Schwartz case, the Lori Drew case. We haven't seen one of those in a while, perhaps with the exception of Assange. But we still see civil claims, also often based upon terms of service violations. Do we anticipate that those are going to continue? What's on the horizon?
Well, I think that one of the greatest protections that has existed for journalists and researchers with respect to civil claims is just the public outcry that would come if a major internet platform, social media company were to attempt to go after a journalist using the CFAA. I think that's why we probably haven't seen it. That said, that puts a lot of power in the hands of the goodwill of companies that are, increasingly powerful, increasingly have a lot to lose from the results of this research, which I think we've seen in the last couple of years, a steady stream of published stories and research that, has resulted in widespread public outcry. So to me, I think those things are on a collision course, which is both the public support for this kind of data journalism, academic research, but also the negative consequences, and the interests on the other side.
Yeah, I would just say on the platforms front that although we don't know of any instance in which they have yet brought a civil action against a digital journalist or researcher, that we are aware of many instances in which they've actually instructed journalists and researchers to stop their projects, essentially, stop their investigations of their platforms, in part because, on their view, those projects violate their terms of service, and the implicit threat there is always going to be the CFAA, that they could bring a civil claim there. So while they haven't yet brought a civil action, that sort of informal, back-channeling on their part is having a chilling effect on this research.
And one thing I didn't go into in much detail is that we do see the platforms regularly use the CFAA to stymie the work of startups that they see as potential competitors. And I don't want to go into a ton of detail here, but I expect that will continue. And then, of course, across all of these vectors, there's the concern that, as in Aaron's case, wherein neither MIT nor JSTOR expressed an interest in pursuit of that prosecution, the criminal liability is coterminous with the civil liability, and you can get a prosecutor who decides that it's in their interest to make a case out of something that a platform wouldn't even particularly care to see made a case of, and run with it and destroy somebody's life.
Well, this has been a great discussion, and thanks to you all for joining in it. I think I would just leave with your point, Esha, which I thought was really well taken. At least in both the criminal and in the civil contexts, so much of this law relies on the prudence of those who could deploy it. And in that sense, it's very similar, actually, to the Espionage Act, which, by its terms for 100 years, could apply to the receipt and publication of government information. But as a matter of prosecutorial discretion, it has not been used against a reporter, with a few unsuccessful exceptions. But it's never been used against a reporter. Part of the reason for that is because there would be broad public outcry, and so it does seem that raising the profile of the issue, and particularly highlighting the dangers that the current state of the law pose to press freedoms, discrimination research, computer research. We haven't touched as much on the cybersecurity and information assurance aspects of this debate, but they're also key. And highlighting the importance of forbearance, at least for the time being, until you can have some kind of concrete fix. But forbearance by those who might use it in a way that isn't optimal. So thank you again. So this is the question that, the eternal question, right? And particularly in the Assange case, does it matter whether Julian Assange was a journalist or not? And the short answer is no. And in issues like this, both the CFAA, the Espionage Act, and other First Amendment considerations, it doesn't matter whether someone is a journalist. And in fact, when sometimes this has to happen, but generally speaking, when the government is in the business of deciding who is or is not a journalist based on some non-functional definition, it can be problematic. That said, there are in the Assange indictment, it makes the superseding indictment emphasizes that the New York Times, The Guardian, Le Monde, and a couple of other outlets that had the same caches of information, that when they reported on those caches of information and when they released some of the specific war logs, the sort of three buckets of things that were at issue there, but one of the major ones was sort of reports from the field. They're called significant activity reports. And the indictment makes a big deal out of that when the New York Times, for instance, published select significant activity reports, it redacted the names of individuals who had been talking to U.S. and coalition forces, and that WikiLeaks didn't do that. That is a practical distinction between Assange and the other outlets, but it is not a legal distinction. So under the Espionage Act, that does not matter. You can make broad claims of national security harm that are not limited to whether or not you named informants. And so, sort of a bit of a rambling answer, but in a lot of the things that we've been talking about right now, the First Amendment doesn't discriminate; it covers everybody, and particularly for specific First Amendment protections. For the free flow of information to the public, another example would be there has been a longstanding rule that so long as you are not involved in any unlawful activity and you lawfully receive material that may have been acquired unlawfully in the first instance, you have First Amendment protection to publish that information. That protection does not turn on your status as a journalist.
Well, yeah, so I think I had said that earlier. I think the concern, and this dovetails into, the discussion of public outcry and what we sort of all see, or maybe we would say there's a consensus of what's a bad act and what's not. I'm not sure that consensus is always necessarily there, but take, for example, an example that's often brought up with the CFAA, which is lying on a dating website, which probably violates the terms of service of most common dating websites. And I think, in our CFAA case, the Department of Justice, provided testimony that it doesn't have an interest in prosecuting those terms of service violations. We all, broadly speaking, understand this is not the type of behavior that we want covered. Okay. But the law still covers it, right? And so I think the risk then, there was a reference to the Myspace prosecution, that involved a woman who had created a Myspace account in violation of Myspace terms of service and then harassed and bullied a teenager who committed suicide. And so what you see there is taking someone, a person who, there might be a consensus that they did something bad, they did something wrong, and then using the tool of this overbroad law because there's nothing else available to prosecute them. And so what that does, again, is it creates this concern that, generally the criminal laws are supposed to tell us as members of the public what behavior is prohibited. So if we all generally know that if I go online and I tell a story about my weekend that isn't strictly true, the Department of Justice is not going to knock on my door, with CFAA charges, or I exaggerate on a dating website. But what if I later do something that isn't a criminal violation, but is bad, or the government thinks is bad, or someone else, or even society at large thinks is bad? Now am I vulnerable, to being selected out for prosecution based on things I've done on the internet that we've all done, right? So I think it's not just selective prosecution in terms of some CFAA violations are worse than others. It's that once you decide someone's a bad actor, that the government wants to go after, you then have these tools you can pick from the very broad arsenal of CFAA charges, which, let's be honest, most everybody who has used the internet has probably committed a CFAA violation at some point, right? So that's, I think, where the real risk comes in.
Yeah, and I this is the classic, like when you're a hammer, everything looks like a nail. But the Espionage Act is a really good example of the dangers of selective enforcement in vague laws. I say this because I work on Espionage Act issues a lot, but it's the classic example of a law that by its terms covers a huge, vast array of activity, but then is used selectively as a matter of prosecutorial discretion. But it results in a huge amount of inequity in terms of who gets punished for what. And so, and this isn't, a new insight. The first reporter, the first journalistic source who was prosecuted under the Espionage Act in the 80s, with the exception of Daniel Ellsberg and the Pentagon Papers in the 70s, that prosecution fell apart. But the first source who was successfully prosecuted was Samuel Morrison, who leaked images of satellite pictures of Soviet ships to Jane's Weekly, and he was prosecuted under the Reagan administration for doing so. But Senator Daniel Patrick Moynihan launched a multi-year lobbying effort in the Clinton administration to pardon Morrison, precisely because his prosecution was so irregular that usually the Espionage Act had been used for spying, but now it was being used to punish someone who had disclosed classified information to a media outlet. And one of Morrison's points there was, when you have a law like this, which isn't entirely clear, which isn't sufficiently clear in terms of what activity it criminalizes, there will be an incentive to use it against folks who don't have the resources, to defend themselves. But then the top brass, who will talk to reporters very frequently, and occasionally will disclose classified information, particularly in the context where they're trying to clarify reporting that could be erroneous about something, or they're trying to prevent actual national security harm. That those actors are not aggressively prosecuted, or can't be aggressively prosecuted also because of issues like overclassification, where the potential for the exposure of other government secrets counsels against prosecution. So it's not directly analogous, but again, it shows the problem of vagueness, right, as a First Amendment concept, and how that can lead to selective prosecution and inequitable prosecution. Any other questions? Great. Thanks so much, and thanks for coming. Appreciate it.